really specifically talk about our procedures for reporting in Minnesota. There's the Federal Indian Child Welfare Act of 1978, or ICWA, and Minnesota Indian Family Preservation Act. Those last two are specifically around children or vulnerable adults who have some Native heritage, and so that's why it's important to note that if you make a report for someone who's got Native heritage, because they fall under separate reporting or separate sort of follow through, separate proceedings that happen after a report is made. So here are the things that qualify for, now we're talking specifically about child maltreatment and abuse. It's any harmful actions by a caregiver or a person in authority that include physical abuse, that's about 36% of reports, sexual abuse is 11%, abandonment, neglect is 61% of reports, the majority, murder, assault, criminal sexual conduct, malicious punishment, and then mental injury or emotional abuse is a very small percentage of reports, and one that we may hear about. It's a small percentage of reports because it's difficult to show the harmful effects of emotional abuse on a child, or that there's not necessarily an event that happens that causes people to report. So that's less of what mandated reporters are talking about when they are making reports. So they make a distinction about what physical abuse is and what is not. Things that are considered reasonable or moderate physical discipline that does not result in injury does not constitute physical abuse. So spanking and those kinds of reasonable punishment or discipline does not constitute physical abuse. Reasonable restraint causing an accidental injury or other accidental injuries, those do not qualify as physical abuse. Everything on the left side there, though, does qualify as physical abuse. Any questions about any of those? Can you see them in the back? Okay. This is all going to be on our intranet after this too, so if you have more questions or want to review my slides, you can certainly do that at a later time. So let's talk a little bit more about what constitutes child neglect. This is failure to supply a child with food, clothing, shelter, health, medical, or other care required for the child's physical and mental health when able to do so. Failure to protect a child from child endangerment, including growth delay and failure to thrive. Failure to provide necessary supervision for a child. Failure to ensure a child's educated. Prenatal exposure to a controlled substance or substance use when responsible for care of a child. We'll come back to that one with a few more details. And emotional harm of a child. So prenatal exposure is probably our most common reporting mandate, that we have to report when unborn children alleged to be prenatally exposed to controlled substances not prescribed to the mother, or alcohol use that's habitual or excessive. We have to report that. So when we have a pregnant woman coming into our program, we have to report her use, and if a woman becomes pregnant in our program, or certainly if our women come in with children and we know that they used while they were pregnant. Those are all times when we talk about making a report as soon as we can. There's some information here about Project Child, which is a program that we work with. Often it's sort of the precursor to child protection for a pregnant woman less than 34 weeks pregnant and over 16. They can be referred to Project Child, which offers them some preventative services to sort of prevent a full-blown child protection case from opening when the child's born. So sometimes we're reporting or kind of referring to Project Child when we're making that report, or getting a woman connected with them if possible. There's one important exemption to reporting right now. This is sort of under debate at the legislature. We'll see what happens to it. But right now we have an exemption that because we're a healthcare or social service professional who are providing a pregnant woman with healthcare or prenatal services, we're exempt from reporting the use of marijuana or alcohol, those two substances only during pregnancy. So if a woman that is all she has been using, either marijuana or alcohol during her pregnancy, we don't have to report that, because the thought process is that we don't want to prevent her from engaging in services with us. We would rather she be in care, receiving health care and prenatal care, than leave treatment because she doesn't want us to make those reports. So they've said that the danger of those substances during pregnancy is more questionable than other substances, and we'd rather that she receive treatment. So like I said, they're debating whether or not to take out that exemption in the legislature this session, and we'll see if they do. We would prefer not to, because of course we want clients to come to us and be open about their substance use during pregnancy. Any questions about that? So a different category is when there is a child in the home and there's drug use or paraphernalia around, what is reportable and what's not. So use of controlled substances and or alcohol by a caregiver becomes a child protection matter when there's evidence of an adverse impact to the child or likelihood of harm to the child due to negligence. So here are some examples. A young child's unattended due to a passed out caregiver, leaving drug paraphernalia or drugs within access of children, or parents driving while intoxicated with children in the vehicle. And those are just a few examples, but you can see it's where not necessarily the use around a child, but when the use produces some harm to the child or potential harm to the child, that's when it becomes a reportable matter. Okay. I'm gonna trust you guys will stop me and put a hand up if you have questions. Because one of the categories of neglect was about supervision of children, I wanted to detail what the time frames are, what the ages are that children can be left alone. And again, this is not about our treatment facilities because we require that women are supervising their children at all times in our facilities. However, if a woman's living outside of our facility and is not a vulnerable adult and is in her own home, should we see that a child who was 3 was left up to 3 hours by themselves, that would become reportable, whereas something within these guidelines is not. It's allowed to be, it's legal to leave children up to a certain amount of time. Sometimes we get questions about older children watching younger children, and sort of what the law says is if a 15-year-old is watching younger children, they can do that up to 24 hours, but again, they're still under those same guidelines that they have to, there's a maximum amount of time that they can be left alone. And children under age 11 are not allowed technically to provide childcare for other children. Any questions about that? Again, if there was a mental, developmental, or physical disability, that these guidelines don't necessarily apply. I mean, we'd have to sort of think about is on a case-by-case basis if that is reportable or not, if they're left alone.
That's crazy.
What?
This timeline.
Okay, we'll get into that later, Bree. Bree's got some questions about the timeline.
I know. I don't agree with it.
Oh, that it's too long?
Yeah.
It's a long time. Okay, so how to report child maltreatment or suspected abuse. So a mandated reporter, like all of us, must report physical abuse, sexual abuse, or neglect of a child when we either know of an incident or if we have reason to believe or we suspect an incident has happened in which a child's been abused or neglected within the preceding 3 years. That's the timeline that we're talking about. So if we find out a woman comes in and she used cocaine while she was pregnant and it was 2 years ago, that's still a reportable, something reportable. And it's whether or not we actually have facts or evidence that something happened, doesn't matter. If we suspect that something has happened, we would need to make that report. Sorry, I'm gonna go back to this one because we recently had a case where, Kelly, can you remind me the details of what they said, that if it was, so we had a client who's an adult now, but as when she was a teenager, when she was under 18, there was some abuse, and she was within that 3 years of that, of being a child. So she was 18 or 19. And so we had some suspicion that there was abuse that happened when she was a teenager that would still be within that 3 years time. And I believe what they said when we called to report was that if it had been physical abuse, they may not have taken that report, but because it was sexual abuse, they did still take that report. So even though she was an adult now, because it happened within the last 3 years when she was a child, they took that report. Is that right?
Yep.
Okay. Anytime we're trying to parse out this, it looks straightforward on a slide, but it's never straightforward in real life, as we all know. So anytime you have a question about whether something's reportable, always go to your supervisor or come to me and we can figure it out. And we sort of are always kind of feeling in the dark, or sometimes are making calls just not knowing exactly what's, what needs to be reported and what's not. Okay. Oh, so a report must be made immediately when we know or have suspicion of the information. So we have to make a report orally by phone within 24 hours of receiving that information, and then follow up with a written report within 72 hours. Some notes I don't want to forget to say. So for child protection, it's county by county. So they make a report to the county in which we believe the abuse happened. So if it's Hennepin County is a lot of our residents, but if they came from another county and that's where, or the child's living in another county and that's where the abuse probably happened, we'd be reporting to that county. So the Hennepin County Child Protection line is listed here, and if it's another county, the best thing to do is just Google to see what the child protection reporting phone number is for the county that you're looking at. And if you don't know, I think you default to Hennepin, they would take a report for another county if the mom's not sure what county it was or things like that, you know, as long as we're reporting it somewhere, we wanna make sure that, and they might be able to give you some guidance about where to make that report. So what information is needed, or what they're gonna be asking for when you make a child protection report is first your information, who you are, that you're a professional. It's always important to say I'm reporting as a professional in this case, what your relationship is to the family, the name of the offender if it's known, the name and details about the children or the victim of, and any other children in the home they're gonna want to know, the nature and extent of the maltreatment, if there's any tribal affiliation, certainly that information, and then if possible, a description of the child's current location. So are they still in that situation or are they not? And even if you don't have all of this information, you still have to make the report. So even if you know you're missing key pieces, you still have to fulfill that responsibility to make the report. Yeah.
If I was making a report outside of working at Wayside, you know, I see something in personal life, would I still have to give the agency that I work for?
No,
Okay.
no, but you would list your relationship to whatever
Yeah.
family or person that you're talking about. Okay, so here's kind of what happens when you make a report. We can report either to the local child welfare agency, that's that county agency, or you can report to law enforcement. If there was ever really imminent danger that you felt like it was an emergency, then you can call 911 instead of making the report to child protection. If it's not an emergency situation, then the child protection agency is the best place to make that report, because we're still, even if we call 911, we probably have to follow up with child protection anyway after the incident's taken care of. So they want to note that the credibility of the reporter is not taken into consideration when making a screening determination. So if someone who's not a professional, or even if, you know, child protection doesn't believe you, that's not theirs to decide. They have to take a report based on the information being given to them, not necessarily deciding whether or not it's credible information. And then they make some decisions within 24 hours of taking a report. So a screening happens, an intake phone call happens, and they have 24 hours to decide if it's going to be an investigation, which is over here on the right side. That's about a third of cases are investigable. And an assessment might happen if it's sort of a low or moderate risk. 2/3 fall into that category of cases that they actually take, or reports that they actually start a process for. So there are some reports that don't ever go anywhere, they don't necessarily do anything with, but these are two sort of processes that can start because of an intake call that they see some risk. If it's moderate or low risk, they're gonna do an assessment. They have 5 days to start that process. And that's gonna be doing interviews and things like that, and determining whether or not it needs to be an investigation, or if it's not at that level and they just need some case management or some services in place to prevent sort of further incidents to happen. If there's severe harm or safety concerns, they're gonna do an investigation. They have between 24 hours and 5 days to do that. And then the product of that is either gonna be some court action, or if not court action, at least some services offered. And they have to inform a reporter if either of these things happen because of your report. I don't know how long they have to do that. I think it's 5 days or 2 weeks. Okay, any questions about child abuse reporting? We're gonna move to vulnerable adults now. Okay.
Jessie?
Yeah.
Is the common entry point then only for vulnerable adults, that's not for
Right.
children?
Yep, we'll talk about that in a minute. So yeah, child protection reports are county by county. There's one common entry point for vulnerable adults. So vulnerable adults, any of you could probably come up here and talk about this. And a vulnerable adult's any person 18 years of older who falls into one of these criteria. All of our clients who live in residential facilities are in a category of people who are vulnerable adults because they're a resident or an inpatient of a facility. So if this is why everybody of our clients is considered a vulnerable adult as soon as they move into a residential facility. And when they move out, we're reassessing, would they be a vulnerable adult anywhere else in their regular life, which would be more of a functional criteria. If they meet functional criteria for being a vulnerable adult, which means they possess a physical or mental infirmity other than physical or mental, emotional, or other physical, mental, or emotional dysfunction that impairs the individual's ability to provide adequately for their own care without assistance, including provision of food, shelter, clothing, health care, supervision, and impairs their ability to protect themselves from maltreatment. So are they able to make decisions and provide that for themselves and protect themselves from abuse outside of a facility? So we have, in a few cases, had a client who was still a vulnerable adult when they left residential treatment, or clients with severe kind of developmental or cognitive needs may still be considered vulnerable adults outside of our treatment centers. So there's an assessment that's done when they leave to decide that, and to decide if then these reporting guidelines still follow them when they leave our facilities, or if they're in outpatient treatment or not. And for most of our clients, they're not considered vulnerable adults when they leave our treatment. So they're really similar kind of things that are required to be reported for vulnerable adults as for children: abuse, neglect, or an additional one, financial exploitation for vulnerable adults. So abuse is all of those things that we talked about for kids: physical, emotional, or sexual maltreatment. Neglect is the failure to provide for food, clothing, shelter, medical care, or supervision. And then financial exploitation. For adults, it's the misuse of their funds, assets, or property, or the failure to use their financial resources to take care of them, which is likely to cause them harm. So just as a protection against ourselves and some rules that we have around not wanting to financially exploit our clients, that we're prohibited from borrowing money, purchasing personal items from clients, selling merchandise or personal services to clients, requiring clients to purchase items for which we are already reimbursed. So we can't do any of these things because that would be considered financial exploitation of our clients as vulnerable adults. There's a lot of words on these slides, and I wanted to put the actual words in the statutes rather than just sort of paraphrase them, because I think I want you to see how it's written in law. So these are all the things that qualify as abuse. Conduct which is not an accident or a therapeutic conduct which produces or could produce physical pain or injury or emotional distress. All of these things. Anybody want me to read them aloud? Good. So, like we were talking about with Beth Ann's question, for vulnerable adults there's one phone number to call. It's the Minnesota Adult Abuse Reporting Center, or MARC is what they call it. And that's the phone number for anybody in Minnesota who's a vulnerable adult that you need to report on. You call that number. And the reason it's called a common entry point is that we make the report there and they disseminate the information to anyone else who might need it. So if law enforcement needs to be involved because there was a crime committed, they will make that connection. We just have to make the report to common entry point. If there was a death, they would notify the proper people, those kinds of things. So it's sort of a common entry point that we can go to that then gets the information out to other people who need it. So they're available 24 hours a day, and they immediately report to the county, anybody else who needs to know. And this phone number is posted in all of our treatment facilities, I hope, and available. You can certainly Google it as well, but we all can look it up for you or find it if you need it. So there are a few circumstances in which a report would not be required. So there are a few cases in which HIPAA so our privacy and confidentiality laws might be more important to enforce than reporting. And this has come up a few times since our audit because they were really advising us to have a release signed on admit for clients saying that we can make reports to that common entry point. So what we're gonna be doing, we haven't implemented this yet, so don't worry if you haven't seen it yet, but there'll be a release with our reporting policy that clients get at admit, that they can choose to sign or not, whether or not they want to give us permission to make a report if we should ever need to. And if we do need to make a report during their time with us, we would have to either have that form or ask them again for their permission to make a report. It doesn't mean that we can't make a report if they don't give us our permission. Then we have to decide, though, if it's making the report is more important than upholding their privacy and confidentiality, or if privacy and confidentiality as a treatment client outweighs our need to report. So it becomes a little tricky, but it's because of this law right here that we have to sort of weigh the importance of those three things: privacy, confidentiality, and mandated reporting. Any questions about that? Okay, so if a verbal or physical aggression between clients or self-abusive behavior, those are not considered vulnerable adult mandated reports unless there's really severe harm that happens. So if a client cuts while she's in our care, or if there's a physical fight between clients, we don't have to report that because it's only vulnerable adults involved, with each other, unless there was something, some severe harm that came out of that. We should, however, record incidents of aggression or self-abusive behavior to make sure that we could, that could come up in a review. So if there is an incident of cutting or fighting between clients, we'd at least want to chart on it so that there's some documentation that that happened. We'd maybe review or talk about whether or not it needs to be a report then. If there's an accident, which is a sudden or unforeseen or unexpected occurrence or event, which couldn't likely have been prevented, or occurs on our site and we have sort of the necessary rules in place, so it was truly an accident, not just kind of malpractice on our part, that is not a mandated report. So if a client falls down some stairs and gets hurt, that's an incident accident form. That's not necessarily a mandated report unless there was something that was really negligent on our parts to prevent that. And then the last one, transfer of money or property by gift or as compensation for services does not constitute financial exploitation. That's just specifically noted in the laws that if a client's paying for treatment, that's not financial exploitation. That's us providing a service that they're paying for, so that's different. So again, there's a lot of information that would be helpful to have on hand when you're making a vulnerable adult report. A lot of the same pieces of information as with child abuse reporting, as well as they like to have some information about behavioral issues, diagnoses, those kinds of things. And again, if you don't have that information or don't feel that's important for the report, you should still make the report. So we have a facility reporter, that's me. So if you don't feel comfortable or don't feel like you are able to make a report on your own, you can report it to me and I can make that report on behalf of you. So that it becomes my responsibility to determine whether your information needs to be reported, and if so, make the report and let you know that I've made that report for you. We can, as an agency, prevent a mandated reporter from making a report. So even if people are like, I don't think that's reportable, but you really feel strongly that you need to make that report, Wayside can't retaliate against you, or we can't prohibit you from making a report. So that is your choice when it's a good faith report, meaning something that you really believe to be true. So if there's an incident at Wayside that is reportable or becomes reportable, our first and foremost priority is going to be to provide immediate care to the victims and prevent further damage from happening. And we'll talk about behavioral emergencies at the end, about how we do that, but that's, again, the first priority. Then it's to report to the proper authorities, so either by the staff person or by me. If there's an incident that happens at Wayside that's reportable about Wayside, then we also have to notify the Department of Health because we're licensed by them as well. So that's not about like if a vulnerable adult had some issue before they came to us or while they were on pass from our facility. That's if somebody at Wayside was involved in an incident that became reportable. So if a client, felt like they were physically abused at Wayside House, then we would have to make another separate report to the Minnesota Department of Health. So then if that happened, that something reportable happened at Wayside, we would do an internal investigation of the incident to try to figure out what happened and figure out if there's anything that we can do to change our processes, make sure that doesn't happen again. And we keep sort of a separate log with those kinds of things, separate from incident accident reports, which we all know kind of that process. This would be separate. We're doing sort of an internal investigation into a reporting incident. Just the seriousness of making mandated reports. A mandated reporter who negligently or intentionally fails to make a report is liable for damages caused by the failure. Facilities that fail to make a mandated report may be subject to a fine, and a mandated reporter who fails to make a report if they know or have reason to believe that a child is being maltreated is guilty of a misdemeanor. So it's really important if we have any suspicion, especially in child abuse reporting, that we make that report. Anybody a person or facility that intentionally makes a false report is liable in a civil suit for actual damages and punitive damages up to $10,000. So never ever make a false report. Again, it needs to be based on actual suspicion or good faith that you have that something happened. So a person who makes a good faith report is immune from any civil or criminal liability, may not be prohibited from reporting by a facility, as we said, is unable to be retaliated against by an employer or others, and their name or identity is confidential unless it comes out in sort of court proceedings that happen after the report is made. We're going to do our examples. We're going to go on to our next training. So does anybody have any questions about reporting while I set this next one up? No? has a hat in here.